'cause you can, you won't, and you don't stop. Or when you can, you won't, and you don't stop. Might be coming out for sure.
In the last module, we went over the fundamentals of the Australian legal system. In this module, what we're going to do is do some fundamentals again, but this time more in terms of concepts and thinking and ways of thinking about legal problems that you might face. We're also going to deal with a couple of fundamental issues that we need to understand if we're going to understand how the law applies in the real world context. That's because we often think of the law as black and white, like there is a law or there isn't, or it says you can do this or you can't, when in fact, many times the law is actually grey, it's not clear. And the reason for that is because of our common law system. So what we're going to do in this module is look at how that greyness develops into black and white over time, how the interaction of statute and judge-made law can reduce uncertainty over time, but means that there's a gap there to begin with when we first enact a piece of legislation. We're also going to look at how lawyers think about particular problems so that you can think that way as well, and therefore understand advice that you might get. I'm also going to look at some alternatives to actually going to court and fighting things legally, because that might not be the smartest thing for you to do in a particular situation. The objectives are to revisit the doctrine of precedent and how it operates. That helps us understand why law might be grey in certain instances. We're going to look at the sources of law and where we can find them, right? To be able to look at something ourselves and not just rely on what someone says. That we can look up what the law actually says. We're going to then look at the interaction between judges and statute, the need to interpret statutes. Why do we have that? How do judges go about it? Then we're going to move on to some legal thinking ideas. We're going to look at the difference between induction and deduction in the use of logic, because logic is central to legal thinking, and it's a great skill that's transferable into all aspects of business. Then we're going to see how logic is used in a traditional problem-solving approach in law. And again, this is a model that you can use in other contexts, not just for law. You can tweak it a little and you can use it to help solve business problems. Finally, we're going to look at some alternative dispute resolution options so that you don't actually have to end up in court every time you have a dispute. So just to revisit, the doctrine of precedent is central to the common law system. It says once a judge makes a decision, then that becomes a precedent and other judges have to follow the rationale that they provide for their decision. However, it's not as simple as that. You don't have to follow every judge, right? The doctrine of precedent says that a binding precedent can only be set by intermediate or higher level courts. So you have to be higher up in the hierarchy, because you are only bound to follow a precedent when it is a superior court or a court above you in the same court hierarchy. So courts are obliged to follow the earlier decisions of courts higher within the same hierarchy. The decision or the reason for the decision by a judge is called a precedent. The only intermediate and superior courts can establish binding precedent. You have to be higher up in the hierarchy. Decisions of courts outside the hierarchy are not binding, but they can be persuasive, so judges often look at them. The only thing that's binding is the ratio, the rationale for the decision. Obiter dictum, or sayings by the way, aren't. Which kind of raises the question, why even have obiter dictum? Why even make these sayings that aren't binding? And actually, what it is it's a signal to the lower courts about how the upper courts are going to decide something, right? So if they see an important policy issue, they might say, look, I don't have to decide this issue in this case, but if a case with this issue did come before me, this is how I would decide it. Now they say that so that the lower courts know how to handle those issues. Because if the lower courts don't do what that superior court said, if they don't follow the obiter dictum, what's going to happen? Whoever loses is going to appeal. And they know how the superior court is actually going to decide it, right? Because they've already told them in the obiter dictum. So it has a highly influential effect on judges, because judges don't like their decisions overturned. And that's why they engage in it, even though it's not strictly binding. You'll remember in the last module, we also introduced this idea of the court hierarchies. Each state and territory has their own hierarchy. So this is Queensland's hierarchy. And we can see at the bottom is the Magistrates Court. The next court up is the District Court. And the top court is the Supreme Court. Now, some courts have more than one jurisdiction: an original jurisdiction, or where cases get heard at first instance, and an appellate jurisdiction, for instance, in the District Court and the Supreme Court. So that's how the state court system operates. Federally, you can see we've got the family court, obviously for family matters, for things that involve children and families. They're highly specialised. We have the federal court system, which is, for want of a better term, the main court system where things are heard. We have, in both those court systems, an original jurisdiction and an appellate jurisdiction. Now, the only other court that we have is the High Court, and I kind of left that till last because it ties everything together. What you can see is there can be an appeal from the full court of the family court, from the full court of the federal court, from the Supreme Court within a state. So every court can end up with an appeal to the High Court. And that is one of the ways that you get consistency across the Australian legal system. Because at the end of the day, the ultimate judicial body is the same for all courts. Now, in that appellate jurisdiction, you don't have a right to appeal to the High Court from these other courts. Because the High Court would be so busy, it has to agree to hear your case. That's something called seeking leave to appeal. So you can seek leave to appeal to the High Court. They essentially say, is this something of such importance that we should look at it? If they say yes, then they will grant you the right to have an appeal to the High Court. You'll also note that there is an original jurisdiction there for the High Court. That's very limited, and it mainly deals with constitutional issues. Because you can imagine if there's a disagreement between the states and the Commonwealth government, how do you decide? That's a constitutional issue. How would you decide that? Well, you probably got to go to the highest court. You couldn't go to a state court or a kind of federal court. You want the court that unites the entire system. So they're the hierarchies that we have, the main hierarchies that we have in the Australian court systems. Now, just to reiterate a bit from the doctrine of precedent, what that means is, for instance, a decision of the High Court is binding on all of the other courts because they're all in the hierarchy, right? But a decision, say, of the full court of the federal court would only be binding on the original jurisdiction, federal court. Notice it's in a different hierarchy to the family court, and it's in a different hierarchy to the state courts. Okay, so that's how the doctrine of precedent operates in practice. I'll leave you to go through these tables and read them in detail, but in essence, each court has a jurisdiction or a kind of level of case that it can hear. It's often separated into civil and criminal issues because they're two different types of law. You'll remember that from Module 3 when we were looking at different classification systems. And what you can see is as you go up the hierarchy of a court, the matters become more important. So a civil claim below $100,000, Magistrates Court. Between $150,000 and $750,000, District Court. Above $750,000, Supreme Court. So as it becomes more important and more complex, it ends up in a higher court with more experienced judges. Same thing for criminal cases. We won't go into detail, but the most serious are heard at the higher courts and the less serious at the lower courts. And just as we have those jurisdictions at the state level, we also have matters that can be heard within the various courts in the federal sphere. We have the family law issues, the federal court, and the high court. It's important that you get a sense of what is heard in these courts because we start to see the intersection between the Constitution, right? Because these courts are only going to hear matters that are within the powers of, for instance, in this case, the federal government, because they're federal courts, versus the state government for state courts. And we also start to see the hierarchy evolve. Put simply, precedent. Courts, for precedent to apply, courts must be within the same hierarchy. Higher courts bind lower courts. A single judge is not bound to follow the decision of a single judge, but is bound to follow a decision of the full court. That kind of brings us to the end of the doctrine of precedent. The doctrine of precedent is why we quote cases. People are going to ask me throughout the course, do I need the case name? Yes, because it's your reference point. It is where the law is. The case is the source of the law because it contains the precedent or the rule of law. That is the basis for the decision. And that operates via this doctrine of precedent.
Started thinking to myself, revolution, it's not coming.